Hello, everybody. Thank you for joining us today. This is a good day to talk about immigration with the attorneys in the law firm of the attorney Margaret W. Wong, who has started this law firm 46 years ago, and she has been working since 1977, starting in the city of Cleveland with no secretary, only one little desk. And then she became one of the major attorneys in the United States, and now in the east of the United States, having the headquarters office in the city of Cleveland, but with offices in several cities of the United States. Today, I'm transmitting from Atlanta, but our attorneys today are connected from the city of Cleveland, from one of the studios there in the headquarters office. So let's welcome the attorneys today, Attorney Robert Radliff and Nathaniel Rucker. How are you doing today?
Very good, sir. Thank you.
Doing well. Thank you for asking.
It's good to have you today, and thank you so much for letting me be part of this show that we have been doing for several years. But today we are lucky that we have two awesome attorneys giving us the information that we need in order to get a relief in our immigration cases. And one of the questions that people have right now is what's going on in the south border, because a lot of people have discussions about the Section 42, people having to wait in Mexico or waiting in Latin America, but also there are some other discussions about what to do if I am trying to come to the United States from Canada. So regarding to this, one of the questions is, who can stay in the United States if they try to come illegally? How can they stay in the United States? I don't know who wants to answer today.
Well, it's an interesting problem right now because the Title 42 is coming to an end, and the Migrant Protection Protocol program that was requiring people to stay in Mexico or the country of origination while their immigration processes were being heard, that has also come to an end. So those individuals are able to get paroled or enter into the United States. There are really two ways that you can enter into the United States. One is an entry without inspection, which means that you just cross the border, whether it's Canadian or the southern border. The other is if you are actually what is called an arriving alien, that you show up at a border checkpoint and you ask for permission to come in because you either have some sort of legitimate tourist reason for coming, or a business reason for coming, or that you're seeking asylum or some other relief in the United States. Now, the interesting part of that is individuals that present themselves at a border checkpoint and claim a fear of return to their home country are considered arriving aliens, and they are, by law, required to be detained while their asylum case is pending. Those that enter across the border in an illegal fashion, those individuals can be paroled in the United States or are subject to a different enforcement mechanism that would allow them to then seek asylum or whatever other forms of relief they want in the United States.
Okay, thank you so much for this answer. And now I have another question because of this, and a lot of people that came in 2021, 2022, especially people from South America that came through Mexico, they are having court hearings now, but many of them are not attending to that court hearing. So what happens to these people that don't go to that first court?
It's very, very bad. Always go to the court hearings.
Right.
What happens if you do not go to the court hearing, if you do not appear, is the court is going to enter what is called an in absentia order. Basically means you didn't show up, you're officially deported. Now, that does not necessarily end your immigration proceedings. There are some reasons that you can have that case reopened. You can petition the court to that you didn't get notice, or you didn't get an appropriate notice. There's a lot of notices to appear that were issued in 2021 and 2022 early on that didn't even have a date and time of when your hearing was going to be. So there are some grounds where you can ask the court to reopen those proceedings. But by and large, if you don't show up, you're gonna be a little bit further behind than the people that do show up, and your chances of prevailing and ultimately getting asylum or some other form of relief are going to be much harder.
And we've seen a lot of cases in which the notices were sent to addresses where the people were no longer there. For example, they were at a shelter and then they left. And the notice came after they had left. So that would be one of the grounds to reopen. But I agree with Rob. If you don't show up, you got a problem.
So what happens if, for example, I came to the United States, I entered through Arizona, and I went to New York, but then I find a job in, let's say, Texas. So I moved to Texas, and I gave my address from New York to immigration. So what happens with that notification that they sent to me in New York if I'm living in Texas?
Under the law, it is your responsibility to notify the court anytime your address changes. And in fact, you're supposed to do it within 5 days of the change of address. You can do that in person at any immigration court by filing what's called a form EOIR 33. Or you can have your attorney do that, or you can even get that form online and submit that. That doesn't always mean that there's not a gap. Sometimes you file that form and it takes it a while for it to get processed. Maybe a notice has already went out. The form sometimes may go to the exact right address, but it may, if you live in an apartment complex, it may get stuffed in the wrong mailbox. Anything like that can happen. So in addition to continually making sure you're updating the court with your address, you also have the extra added responsibility of needing to check with the court. Judges are going to ask you when you didn't show up, say, well, look, you knew you had immigration court. Even if you didn't get this notice, why weren't you checking in with the court to see what your hearing date was? Judges commonly ask that. So don't just assume that because you haven't got a notice, nothing's going on. It's always good to periodically check in with your attorney or have your attorney check in for you, or just do it yourself and call the immigration court and say, hey, when should I be there?
Okay, thank you very much, attorneys, for this answer. And well, this is awesome because we're doing something new today, and I really like it, that I have two attorneys to talk about immigration today. So thank you so much for your time. We have a first question coming from our audience, and it says, hi, how are you? My name is Akash Patel. I applied for U visa on June 2022. So how long would the work authorization card to arrive? Thank you.
That's a big question right now. The work authorization cards and the processing times have been greatly delayed. It's just a matter of immigration and CIS processing those cards and those applications. There's just an overwhelming number of them right now. It normally, 2 years ago, you would get that back in 180 days. A year ago, less than a year. Now we're hearing dates as long as 550, 600 days to actually get that card. It's creating a lot of problems for people down the chain as well, because they're not able to get driver's licenses. They're not able to get some other documentations. It's creating problems for kids in school. So right now, there's not a good answer to it. It is taking a long time. Stay in touch with immigration. Stay in touch with your attorney. Make sure you're checking in and not doing other things that are going to create problems for you. If your license didn't get renewed, I know it's tough, but try not to drive, because if you get caught, that can be a problem for you. The more delay that you have in that work authorization, it creates more problems for you. So you just got to be very, very careful.
Very, very careful. Traffic violations are one of the number one ways that ICE will catch up with you and detain you. And if you don't have a valid driver's license, that could be a huge problem. And please, please do not drink and drive. Please don't do that, because that is the death sentence in immigration proceedings.
Okay, thank you so much for these answers, attorneys. And today, if you have any question, just feel free to write it down in our post on Facebook or our YouTube channel, and they will answer your question right away. And today, we have more questions coming, but if you need more information, you can call. The phone number is 216-279-3984, 216-279-3984. Hello, good people. I am on TPS with EAD, also advanced parole, and also with pending U visa and recently EAD approved. Can I travel? Will I have any problem having two status? Thank you so much.
If you have that advanced parole application filed and pending, you really should wait on that. You generally are not going to have trouble traveling, but that advanced parole guarantees your entry back into the United States. It's always the best option to get that advanced parole filed and travel with that advanced parole certification, especially when you have something additional like that pending U visa. You don't want to do anything that's going to harm your situation there.
Okay, thank you so much for this answer, and Gautam. We hope that you are satisfied with this answer. And if you need more information, just give us a call, 216-279-3984, 216-279-3984. I have a court in May, but I was planning not to show up. I entered on parole through Mexico. Someone told me that the important court is the second one. I am applying for asylum.
I'll take this one.
Yes, you should.
No, don't do that. Show up to the first one, because if you don't, the order in absentia could be entered against you at that particular point in time. You do not want that to happen. All of your court dates are important. Please understand this. There is no one that's more important than the other. They are all important. So if you have a court date in May, please stay in touch with your attorney, appear at your court date, and then if there is another court date, you show up to that one, and if there is a third one, you show up to that one. But if you don't show up to the first one, there will not be a second one. There will not be a third one.
Okay, thank you so much. And this person is adding, so should I go if I don't have an attorney?
You can go without an attorney, and you can respectfully request time to retain the services of an attorney, and they will give you that time. Generally, if you're detained, they give you a couple of weeks to do that. If you're not retained, they give you a little bit longer time. But the bottom line is that you need to, especially in immigration proceedings, you do need to have an attorney, and you should retain one as soon as possible.
Okay, thank you.
And when you do retain them, when you do retain them and you talk to them for the first time, you should give them all of your documentation at that first meeting so that they are not trying to chase you to find documentation. So all of your tax returns, all of your birth certificates for you, your children, your spouse, their medical records, everything you have, you should bring it to that first meeting so that they have it.
Okay, thank you so much, attorney. And well, if you need more information or you need an attorney to go to your court hearing, please make sure that you call the office 216-279-3984, 216-279-3984. Interesting question here. This is very common, sadly, in the Hispanic community. How about it's a simple battery case for an asylum pending person?
You want me to take that one?
Yeah, go ahead.
I got that. Okay. It can be bad. It depends. And I'm not trying to be funny. It really, truly does depend. It's not good. And preferably if you have a pending battery case, you should see if your attorney can get you a deal with the prosecuting attorney's office for something less than a battery case. Like, say, for example, disorderly conduct or something of that nature, something that is not viewed as a crime of violence. Depending on the DHS attorney will depend on whether, if you are convicted of that simple battery case, whether they wish to pursue removal proceedings against you. So
one of the things that's important to remember in immigration court is it's your burden to prove that you're eligible for relief. So it's your burden to prove that your simple battery charge may not be a crime of violence. And if you've pled guilty to a vague statute or to a section of the statute that's undefined, you can no longer meet your burden of proof to prove that it's not a violent offense. So it's very, very important to make sure that you've pled to a section of the offense that is not it's going to have the least amount of impact on your immigration case. You're also entitled under the law to seek immigration advice before entering into any kind of a plea agreement in your criminal case. So if you're not comfortable with any kind of plea agreement in any kind of criminal case, you let the court know that you need to find out what the immigration consequences of that plea agreement are going to be.
And you should definitely do that first. Definitely. We have a situation now that I am involved in which, unfortunately, the client has already pled. And I don't know what the criminal defense attorney is going to do, but they're trying to vacate the plea. That's kind of closing the door after the horse has been let out of the barn, so to speak. So it's always good to get that advice up front.
Okay, thank you very much, attorneys, for these answers. And well, this is awesome. All the answers that you are giving our audience, because people want to know about immigration. People want to know about what's going on in the immigration world. So the attorney Margaret W. Wong started this office 46 years ago, and well, the offices now are in the city of Atlanta, Cleveland, Columbus, Chicago, Nashville, New York, and Raleigh, North Carolina. And the phone number is 216-279-3984. 216-279-3984 is the phone number that you need to call if you need immigration advice. So please give us a call, 216-279-3984, 216-279-3984. Roshan says, I had my citizenship interview. I passed the exam and interview. They needed additional documents before my oath regarding my stay out of the United States for more than 6 months. I submitted the documents, and it has been more than 3 months since their submission. Can I travel out of the United States?
Yes, that's assuming you still have a valid green card. There's no restrictions on your travel. There are restrictions on the amount of time you can stay outside the United States. So you want to be very careful that you've calculated when you've been in and when you've been out of the United States, and what those travel dates are, and how much time out of the United States that adds up to. But yes, with a valid green card while your citizenship is pending, you certainly are able to travel.
Okay, thank you so much for your answer. And please, Roshan, if you need more information or more advice, give us a call, 216-279-3984, 216-279-3984. This question is coming from our YouTube channel. Hi, my husband is U.S. citizen. He wants to file for me. But when we went to the attorney, he said that I could not get a relief because I brought my 2 grandsons when I crossed the border. And is there any way that I could fix this situation?
Generally, bringing your grandsons wouldn't be something that would affect your eligibility for adjustment of status based on marriage to a citizen. Now, the manner and method of which you cross the border, that may impact it. So if you cross the border in, the traditional way, that you didn't have any inspection, you crossed the river or through the desert or, through the wilderness in Canada without any inspection at the border, without a visa when you entered, then that is a very difficult situation. You may have some grounds that would allow you to adjust status, but every case requires really specific attention to detail to determine whether or not you'd be eligible for one of those possible waivers. So I would advise you to take all your documentation to an experienced immigration attorney and have them take a look at everything and see if there are any waivers that you could qualify for. Just bringing your 2 grandsons by themselves should not impact it.
Okay, thank you so much for this answer. And well, is there maybe a waiver that this person could apply for?
There may be. When you've entered across the border unlawfully, there are waivers that you may be eligible for. There are also conditions that prohibit you from being eligible for those waivers. The most common one is multiple entries and exits. Individuals that have came one time and stayed, there's a lot of waivers that are available for them. They're complicated, they require hardship, they require a lot of work, but they're available. But when you've came and left multiple times, which is very, very common, then you're subject to what's called the perm bar. And that prohibits you from any adjustment of status in the United States for a significant period of time. So every case is an individual case. You got to look at all the facts and circumstances, but it's definitely worth checking into.
Okay, perfect. Thank you so much. Don't forget the phone number is 216-279-3984, 216-279-3984. Good afternoon, attorneys. My wife abandoned me and my 2 kids. I don't know where she went. I was told that I could file for VAWA.
It's possible. If your wife was a United States citizen or a permanent resident and your children have obtained that status as well, you may be eligible to apply for some sort of a VAWA petition. It would depend on a lot of the facts of your case. I would definitely suggest you sit down with an attorney, go over the entire history of the case, look at your manner and method of entry, the status of your kids, and then we can take a look and see whether or not you would qualify for a VAWA. But the short answer is yes, it is possible, but it's going to depend on a lot of the facts and circumstances specific to your case.
Okay, thank you so much, attorney, for this answer. And this next question says, my husband has been detained for 2 months. He's in removal proceedings now. He got detained and put on hold. We have 4 kids, and he is the sole income of the house. He has been here for 15 years, and we want to know what are his chances of winning his cancellation of removal case.
Well, it's always hard to give somebody an estimate on what the chances of success are when you don't have a lot of the detail. But cancellation of removal cases are something that are routinely granted in courts. You do have to show a very high standard. You have to show that it is an exceptional and extremely unusual hardship to your U.S. citizen children and family if you were deported. Now, that's a very high burden, but it's not an impossible burden to meet. So you definitely want to gather all the documents, gather your kids' education and medical records, and sit down with an attorney and plan out your case, plan out your defense, and how you're going to argue that to the immigration judge.
Also, there's a concern as to why your husband is being detained for 2 months. Is there like a criminal case pending or something of this nature, or does he have more than one OVI or something of this nature? Those things will also affect whether he will be able to be successful on his application. So.
Okay, thank you so much. And this person says that he had like 3 charges: impersonation, he was driving without a license, and he lied to the officer that detained him.
Those are very common offenses, especially in the immigrant community, because of lack of documentation. So it's not something that's going to prove fatal to the case. It's definitely something that you're going to want to deal with and deal with appropriately. But you're in the position now where you're going to have to pursue that cancellation of removal, and it's just a matter of getting it documented and working with your counsel to get everything in front of the judge that you can.
As soon as possible.
Okay, thank you so much. As soon as possible. That I think is very common in immigration. As soon as possible, we have to do everything we can, because if we don't do that, we have a lot of deadlines that we need to meet. And what happens if I file something 1 or 2 days after the deadline? Is that too bad, or it's sort of bad but not too bad?
It really depends. It really depends on what the form of relief you're filing. In immigration court, the judges have a lot of leeway to say that something is acceptable, even though it's filed late. You don't want to file it late, but if you can demonstrate to the judge good cause as to why it needed to be filed late, that's not too bad. But sometimes when you miss your filing deadline for CIS and applications that you have pending with CIS, they're very strict on that. The most strictest of all is the Board of Immigration Appeals. If you miss your filing deadline for a Board of Immigration Appeals issue, it's over. They won't consider anything that's filed late. So it's very, very important to know what stage of the proceedings you're in and make sure that you're trying to stay on top of those filing dates as best as possible.
And from a litigation perspective, we would rather have the information than not have it, so that we can at least try to present it to the court. And if we don't have the information, we can't present it. And if that information would have helped your case and we didn't have it, that's not a good outcome. So we would always ask, give us the information. We would like it as soon as possible, but give it to us when you have it, and we'll make sure we can try to do the rest.
Perfect. Thank you so much. We have only 4 more minutes, and our show is going really, really fast. So thank you so much for having you two talking to our audience. I think we never did this before, so this is a brand new show today with the attorney Robert and attorney Retanio, who are talking about immigration and also criminal cases that a lot of people, just because of lack of knowledge, we commit crimes and that we don't know are crimes. For example, spanking a child, a kid, that's too bad. Or is in some states, I think it's you are allowed to do certain things, but other states are really severe with those situations.
I think our former juvenile court judge might have some input on that.
It depends on the state that you're in, quite frankly. You are allowed to discipline your child. Please don't get that wrong. You may discipline your child, but there's a fine line between discipline and abuse. And that's where the criminal aspect comes into it. If the prosecuting attorney deems it fit that you have committed some kind of abuse toward your child, that can in fact be a problem for your immigration situation. And that can falls under crimes involving moral turpitude. And you do not want to have that particular situation. So you need to be very careful. And parenting nowadays is a very different situation. It is not like when I grew up or some others grew up, when your parents basically you did what they told you to do, or else they knocked you into the middle of next week. No, that cannot happen anymore. Okay, you have to find different ways. And if you are charged with somehow child abuse, or if you have a children and family services case, that can be detrimental to your immigration case. So you have to be very careful with those situations.
Thank you so much for clarifying this situation to the people, because we come from different countries, and there, let's say it's kind of permitted. Let's not say it's illegal, but it's kind of permitted. But here in the United States, things are different. 2 more questions to go. I have a hit and run. My wife is an U.S. citizen. She wants to file for me, and I entered illegally. How bad is this for my case?
It's not good. It's not good, but it's not something that's completely unworkable. Right. We have to look at the specific facts, and the fact that you entered illegally is almost a bigger issue than the fact of the hit and run. So for the illegal entry, you're going to have to be able to show some hardship to a qualifying relative, in this case, your spouse or a parent, and we can look at the totality of the circumstances, see what kind of hardship is out there, and take a look. You may be able to do something. I would definitely suggest you consult with an attorney to look at your entire case.
And with respect to the hit and run, is it still pending, or has it been resolved? If it's still pending, then there's a there's an opportunity for your attorney, whoever that is representing you, to try to get a different kind of plea from the prosecuting attorney's office. If it's already been resolved, then some other issues may arise. For example, were you given the appropriate immigration warnings when you either took the plea, that kind of thing. So we need to know more of the specifics. But yeah, I agree with Rob. The fact that you entered illegally concerns me more than the hit and run piece.
Okay, thank you so much. And I guess he did the hit and run because he didn't have a driver's license. So that's what I guess. It's very common as well.
I got that, but I'd rather them charge you with not having a valid driver's license than a hit and run. It's just a matter of degrees.
That's true. Okay, thank you so much. And the last question for today: what happens if I stop reporting to ICE?
They're going to come after you. That's the simple answer. You got another?
Yeah, it depends. It depends too on why you're reporting to ICE, and the why you're reporting to ICE is going to determine what the circumstances of what happens when ICE does come look for you. But yeah, the short answer is if you stop reporting, now you're on the list, and somebody's going to knock on your door.
Right.
Okay, thank you so much. And maybe not right now, maybe not tomorrow, but one day. And I would say right now we are kind of quiet with those kind of situations. But if we go 3 years back or 4 years back, people were really, really scared of getting someone knocking at your door and asking for your name and last name. Right. So thank you so much, attorneys, for your answers, for your time. Attorney Robert, Attorney Rutanio, and I hope it's not the last time that we have you in the show.
We'll be back.
We will. We seem to be a package deal.
Okay, that's awesome. Thank you so much for your time, and for everybody who has joined us today. Thank you so much for sending your questions. Don't forget, you can call the office. The phone number is 216-279-3984, 216-279-3984, in the office of the attorney Margaret W. Wong and Associates. Over 46 years working in the immigration field and helping thousands of families get an immigration relief. Thank you so much, and see you next time.